Welcome to HIT Podcast, HIT, Human Resources, Insurance, and Technology. I'm your host, Toby Kennedy. As we do every week, we are dropping into your feed with what I hope are bite-sized, digestible, well-curated conversations going on in the space. This week's episode will be absolutely, positively no exception. Super excited. This week's episode is brought to you by Montage Insurance Solutions. And without any further ado, we get right into friend of the show, Brian. Brian, how you doing, my friend?
I'm doing really well. How you been, Toby?
Yeah, man. Awesome. So longtime guests and viewers will know about your fantastic, deep acumen in the space. But if you can just give me another quick, brief intro, kind of who are you, how you find yourself in the chair, and why you are my handpicked choice to go over some of these crazy legal updates in the space.
Absolutely. Well, my name is Brian Koegle. I am the managing partner from Koegle Law Group. We are a small but mighty group of attorneys in Southern California primarily, although we are now practicing in 6 different states, advising employers on multiple business and employment regulation compliance issues. My sweet spot, quite candidly, is focusing on employment law compliance for California employers, trying to keep them out of trouble. And then, unfortunately, when they forget to call me or they don't take our advice or they aren't working with us beforehand, they find themselves in litigation, and then we defend the business through litigation processes and try to get them out of the pitfalls and perils as quickly as we possibly can.
Yeah. Well, I imagine that's probably really few and far between in California because there's really no laws that hit the employer and they're just kind of allowed to do whatever they want.
Sure. Very pro-employer state, California.
Well, I appreciate you being on. I appreciate every time I've ever seen you in person. I've seen you keynoting and just crushing lots and lots of stages along the way and previous episodes. So anyone go back and look for Brian's previous episodes. But here we are rounding the bend into a new year, 2026, which for me is the year of the World Cup. And I am so very excited about that. But for some employers, it might be the year of some new laws. And so hold on to your scooters, boys and girls. We have a segue. Can you take us into a quick overview of maybe just a couple of things that are either like absolutely down the pike or getting flirted with coming down the pike, or hey, employers, you might have heard this or you might not have heard this. I just kind of want to let you wrap a little bit without a ton of guidance because you're just such a wealth of knowledge in the space.
Yep. Well, listen, 2025 was a really interesting year. It started out very slowly. We didn't think there was going to be a lot of legislative change. And then towards the end of the legislative session, there were a flurry of bills that were passed. There are actually 12 of them that were passed by our legislature in late August and early September. I'm going to touch on about 4 or 5 of them today. But before I go into the new legislation, I do just always want to remind every business owner out there, January 1st, you got to keep your finger on the pulse when it comes to the minimum wage. Now, you may say, I'm not a minimum wage employer, Brian. This doesn't affect me. Oh, yes, it does. Anytime the bottom comes up, everybody else trickles up with it, right?
Yeah.
So if you've got somebody who's earning 23, 24 bucks an hour, and they find out that the bottom end of the employment scale is going up in January, it's going from 17 or 1650 in California up to 1690 in California. But also, you need to beware. A lot of these different municipalities, depending on where you do business, San Francisco, Oakland, Los Angeles, San Diego, they all have their own regulatory schemes. Los Angeles, just as an example, they're way above the state average. They're at $17.87. Those people who are working in West Hollywood, they're at $19.65 an hour.
That's wild. Yeah, that's so tough for employers to keep track of.
Yeah. And along with the minimum wage, this also increases the annual minimum salary for any of your exempt employees, right? So this year, going into 2026, we're going to see yet another jump up to $70,304 a year. So make sure that those exempt employees are getting a pay bump on December 31st so that you're meeting that minimum salary. Because if they fall below that minimum salary, it doesn't matter if it's the CEO of a company. If they're earning less than $70,304 on their monthly draw, then they are not going to meet the minimum salary threshold and they will revert back to non-exempt hourly status.
Wow. Yeah, that's tough to follow. And I think even in LA, correct me if I'm wrong, but like, isn't there even a distinction between what the business does Like the sort of fast food or restaurant
Oh yeah.
minimum wage is different. So even within local areas, the business codes can even be different. Yeah.
That's exactly right. For minimum wage or for fast food workers, the minimum wage is $20 an hour. If you work in the healthcare industry in June of this year, of 2026, it's going up to $25 an hour, regardless of whether or not they're actually performing medical services. So this is anybody who works in a health facility, hospitals, medical clinics. Your janitors need to be
Yeah.
making $25 an hour.
Yeah. Wow. Wow. Okay. Well, this is exactly why we have you on and why
Yeah.
I assume your phone rings 365 days a year. And what's the next scary thing to check under our bed for?
So we've got a couple of new notices that are going to be required for 2026 that I just want to alert all businesses to. The first one, I laugh about this. The legislature came out and they said, we want this out on January 1st. And we're going to order you to post a new notice. Well, the California Civil Rights Division came back and said, well, we're not going to have a notice ready by January 1st. So the legislature ended up pushing
I
this
feel like that
notice
happens all the time with these guys, by
all
the
the
way.
time, guys.
Oh
But
man.
now our deadline is going to be February 2nd or February
Okay.
1st, 2026. We are going to get a new template notice. It's called the Know Your Rights Act.
Mm.
Basically, what's going to be included on this, and it must be provided to all new hires as well as your existing employees. It's got to have specific workers' compensation data, including your policy number, your carrier, who to contact in case of a workers' comp claim. You have to instruct as to what employees are to do in case an immigration inspection comes across their path.
Hmm.
Who is the emergency point of contact? What are they to do if ICE comes knocking at the door? Third, they must notify employees as to their union organizing rights. It basically is an encouragement for private employers to tell their employees how to contact the union if they want to unionize. And then finally, how to interact with law enforcement within a business construct. So these 4 points must be on this notice. They are publishing a template notice that we should have by early January. This needs to be rolled out to all of your employees by February 2nd or February 1st of 2026. You can send this out by personal service, email, text method, or anything else that ensures delivery within 24 hours. So if
And
you
I
have
guess a little inside baseball for the listener. We're taping this in mid-December, so the notice isn't out yet. But by the time this airs in early to mid-January, that thing should hopefully be out.
we're hoping, fingers crossed.
Yeah. So where we
But
sit today, we're expecting it.
But the one last thing I want to touch on this is you, the employer, have an affirmative obligation to maintain a record of that notice that you provide each and every year, because it has to be updated each year. And you have to confirm delivery to all of your employees, and you have to maintain those records for no less than 3 years.
That's wild.
Yep. So you think that one's crazy? I got another one for you. You know how we used to have tuition reimbursement agreements,
Yep.
or you have a signing bonus with an employee, but if they leave within a couple of years, you want to be able to claw that money back, right? Because
Yeah.
the whole purpose is we want you to improve yourself, come to work with us, and we're going to give you an incentive to do this. Well, the legislature is not a big fan of these, what they call stay or pay agreements.
Mm.
So they created something called the Training Repayment Agreement Provisions Requirement, TRAPS, because that's you got to love that acronym, right? So the
Oh
legislature
man.
looks at these as traps for employees. So you need to be sure that you have a written separate agreement for these type of things now. So if you provide an onboarding bonus, let's say you provide $50,000 for a top end executive to leave their job to come to you, but if they don't stay with you for the next 2 years, they have to repay it. Well, number one, it has to be prorated repayments. You can only have a maximum employment period of 2 years that you can mandate under this. It has to be fully voluntary, knowing waivers of their rights and claims under the act. Additionally, if you violate this and your agreements do not meet the standards of the new TRAP Act, then it is a penalty of up to $5,000 per employee for every one of these agreements you have out there. So reconsider your reconsider your onboarding bonuses. Think about having a retention bonus. Hey, if you're here for 2 years, we'll pay you the $50,000 at the end of 2 years.
Right. Right.
Fun.
Right. Right. Yeah, that's smart. And that, like you said, goes with the tuition reimbursement is the same sort of kind of deal and scope there.
That is exactly right. That is exactly right.
Okay. Well, you mentioned you had three or four things burning on your mind. We've hit three highly scary and terrifying things. I almost hesitate to ask, Brian, has the legislator done anything else?
But wait, there's more.
Oh no.
Absolutely, Toby. So the expanded personnel file requirements of Senate Bill 513 are also coming into play January 1st of 2026. This now requires all employers in the state of California, regardless of size, to maintain as part of their personnel and employment records anything regarding training and education of their employees, anything that is done to expand beyond performance and grievance documentation. So every time that you put an employee through sexual harassment prevention training, there must be a written record maintained in the file that includes not just certification and proof of completion, but it has to have the employee's name, the training provider, the duration of the training and the date, the core competencies that are trained upon, and then any resulting certifications. These documents must be maintained in a personnel file, which means that an employee has a legal right to inspect those training files upon 30 days notice. That's pursuant to California Labor Code sections 432 and 1198.5. If you have not already started this process, folks, make sure you're doing it now, because the documentation that is kept in these personnel files is what's triggering a lot of litigation right now. And if you don't have a well-maintained employment documentation file for these folks, and you're scrambling when they make their request to compile from different locations, it's a bad practice. So the best practice is make sure you've got comprehensive, complete, and thorough employment records maintained for every single employee, and that you're maintaining those records for no less than 4 years. 4 years. Let's see if I can put my fingers up correctly. Four
We
years
don't count thumbs. Come on.
from the last from the last date that they worked for you.
That's wild. And as you said, that's regardless of size.
That is regardless of size. That's correct.
I mean, I think that that's going to trip a lot of employers up. And it's like, when you say training and then you say sexual harassment training, can you think of any other examples, or is it literally just sexual harassment training?
Oh, no, absolutely. So any sort of safety trainings, a lot of our clients, Toby, they do tailgate meetings, for instance, right? This is how we make sure we're wearing our personal protective equipment. For our tree climbers, this is what you need to do if you're climbing trees. For our manufacturing employees, we've got to train them on how to safely use the equipment and the manufacturing equipment that is in their care. We have all of these trainings for safety protocols. Additionally, if you have OSHA compliance trainings, if you've got workplace violence prevention trainings, and remember, we're supposed to be doing those every single year, folks. So if you don't already have your workplace violence prevention plan in place, you need to have it for 2026, and you need to train all of your employees on it.
And you need to document that, and you need to hold it for 4 to 6 years, depending upon if we count thumbs.
That's exactly correct. That is exactly correct. So the burden is being pushed onto the employers even harder now to make sure that we have these thorough records to prove that we're not setting our employees up for failure, right? The legislature wants to make sure that we're setting them up for success, not for failure.
Yeah, but I just constantly hear this stuff. I'm like, how are, especially smaller employers, like, how are you supposed to know this stuff?
Well, I
You
mean,
get sued?
this is the beauty of why I've got the greatest job security in America.
Right.
Because a lot of the smaller employers don't listen to podcasts. They don't get to come out to training sessions
Right.
themselves. It's imperative that you keep yourself informed on these things so you can stay ahead of the curve.
Well, how is a good way for people to get a hold of you if they're listening to this and saying, hey, he mentioned that he could help me after the fact if I don't call him on time and we have to litigate, but perhaps if he can get a hold of him ahead of time and we can write a
100%.
handbook or we can do any number of things.
Well, and this is the best time to reach an attorney right now, is the beginning of any calendar year,
Yeah.
because that's when the laws change, right? We have to roll out new policies and procedures. Additionally, quite candidly, it raises fewer red flags with employees when all of a sudden you start rolling out more specific policies and you say, it's not our fault, it's the legislature. The law changed this year.
Right.
We have to roll this out. So reach out anytime. You can reach me via telephone, 661-362-0813. You can email me anytime, bkoegle at koeglelaw.com. That's bkegley at kegleylaw.com. And you can always reach us through our internet platforms, either on LinkedIn, Facebook, Instagram, and my website is kegleylaw.com.
Brian Koegle, you are an absolute legend. I appreciate you so deeply for being here. Thank you for our rundown on what's new for 2026. Folks, this is part one of a two-part series with Brian. We're going to have Brian on next week talking about, hey, this might not necessarily be new, but this is stuff people are still getting tripped up on. So thank you very much for joining us this week. Look forward to part two next week. That's all the time we have for you this week on the show, folks. Thank you so much to our sponsors, Rula, True Hue, Montage Insurance Solutions, the folks keeping the lights on. We're blessed to be here. We appreciate being in a new year with you guys. Join us next week. Join us every week. And until next week, make this the best week yet.